Julian Assange, the 52-year-old Australian and founder of WikiLeaks, is currently incarcerated in Belmarsh Prison in London. Why is that? He was originally sent to Belmarsh Prison after being convicted of failing to surrender to the custody of the court and was sentenced to 50 weeks in prison. His sentence of 50 weeks expired in April of 2020, but he remains in custody. Welcome to my channel Andy on Crime, where I look at high-profile criminal cases and other aspects of criminal law in England and Wales. In this video, I'm going to explain the circumstances behind Julian Assange's arrest, what he was actually charged with, and why he was sentenced to 50 weeks in prison. I should say at the outset that I know there are very strong opinions in relation to the arrest and incarceration of Julian Assange, and some of the facts are disputed. I will try and be as balanced as I can be in outlining what has happened, and whilst appreciating that there are different narratives from people, and I know that some of what I say will be disputed. Feel free to correct me in the comments if I've got anything wrong, and I'm really happy to engage and debate respectfully with people over these videos that I produce. My main focus in this video is to explain the law behind his conviction and imprisonment for 50 weeks, recognising that the truth in this is somewhat complicated. With that being said, let's get into the video. The first thing to talk about briefly is WikiLeaks, which was founded by Julian Assange. Now, WikiLeaks is a whistleblowing platform and was established to obtain and disseminate classified documents and datasets from anonymous sources and leakers from various countries and governments. Its own website states that WikiLeaks specialises in the analysis and publication of large datasets of censored or otherwise restricted official materials involving war, spying and corruption. It has so far published more than 10 million documents. And Julian Assange has stated that WikiLeaks is a giant library of the world's most persecuted documents. We give asylum to these documents, we analyse them, we promote them, and we obtain more. Now, WikiLeaks released hundreds of thousands of US military documents and videos from Iraq and Afghanistan. They also released a trove of more than 250,000 State Department diplomatic cables in 2010. Perhaps the most famous and high-profile case involving WikiLeaks was the former soldier Chelsea Manning, who was convicted of leaking the documents and was sentenced to 35 years imprisonment, later commuted to 7 years imprisonment by President Barack Obama. Now, the work of WikiLeaks creates a really interesting ethical dilemma between governments holding material relating to their activities, some of it very questionable and potentially unlawful, and the rights of ordinary citizens to know about them. So why were the UK police looking to arrest Julian Assange in 2012? Well, the official narrative for Julian Assange's arrest by the UK police, which I've taken from the sentencing remarks in relation to his Bail Act offence, something which I will cover later in the video. The official narrative is that on the 24th of February 2011, Westminster Magistrates Court ordered Julian Assange's extradition to Sweden to face allegations of sexual offending, including an allegation of rape. Now, Julian Assange denied the allegation and appealed against this decision and was granted bail on conditions and was allowed to appeal a number of times, which culminated on the 14th of June 2012 with the rejection of his application to reopen the Supreme Court's original dismissal of his appeal. And on the 19th of June 2012, he entered the Ecuadorian Embassy. On entering the embassy, Julian Assange stated, "I can confirm today that I have arrived at the Ecuadorian Embassy and sought diplomatic sanctuary and political asylum. This application has been passed to the Ministry of Foreign Affairs in the capital Quito, and I am grateful to the Ecuadorian ambassador and the government of Ecuador for considering my application." Julian Assange's principal concern about the extradition to Sweden was not the allegations themselves, but a fear that it could be used as a pretext for his subsequent deportation to the US to answer for charges relating to the disclosure of classified documents. And with all avenues of appeal now exhausted in relation to his extradition, on the 28th of June 2012, a notice requiring his surrender to Belgravia police station on the 29th of June 2012 was served on him in the Ecuadorian Embassy. And he did not surrender, and a warrant was issued for his arrest by Westminster Magistrates Court on the 29th of June 2012, the same day he was required to surrender to Belgravia police station. And this is where I'm going to briefly delve into a little bit of law. Now, as this was an extradition case for which Julian Assange was a party to the proceedings, i.e. the person with whom the extradition had been granted, he was subjected to the Bail Act of 1976 whilst his appeals were ongoing. So just like any standard criminal offence where a person is granted bail rather than being remanded into custody, he is required to comply with the requirements of the Bail Act 1976. And under Section 7 of the Act, if a person who has been released on bail in criminal proceedings and is under a duty to surrender into the custody of a court, fails to surrender to custody at the time appointed for him to do so, the court may issue a warrant for his arrest. In plain English, as the appeals process against his extradition had concluded and not succeeded, he was required to surrender to the custody of the court, in this case Belgravia Police Station, by the 29th of June 2012. By failing to comply, the court exercised its power under the Bail Act of 1976 to issue a warrant for Julian Assange's arrest. Julian Assange, however, remained in the Ecuadorian Embassy, and on the 16th of August 2012 he was granted diplomatic asylum status. With regards to the allegations in Sweden, Julian Assange's lawyers offered a compromise in which Swedish investigators could interview him in person in London or by a video link, but the Swedish authorities decided not to take them up on that offer at that time. So Julian Assange remained in the embassy, knowing that if he were to step outside of the building, he would be subject to arrest, as the police were stationed outside to execute the warrant of arrest for failure to surrender to the custody of the court. Now, Julian Assange's refuge at the Ecuadorian Embassy garnered huge media attention, with a number of high-profile figures calling for him to be allowed to be released without being arrested. On the 5th of February 2016, the Office of the United Nations High Commissioner for Human Rights announced that the Working Group on Arbitrary Detention, this is a body of independent human rights experts that investigate arbitrary cases of arrest and detention, had found that Assange was effectively being held in arbitrary detention by the UK and Swedish governments. This was dismissed by the UK government as ridiculous, and their position was that he was a fugitive from justice who could come out of the embassy at any point. Now I'm going to fast forward slightly because I want to talk about the arrest and sentence of Julian Assange under the Bail Act, so please forgive me if I've skipped over any important details. I'm sure you'll remind me in the comments. Now, on the 19th of May 2017, the rape allegations against Julian Assange were dropped by the Swedish authorities. Mr. Assange's Swedish lawyer, Per Samuelsson, said that the prosecutor's decision on Friday represented a total victory for his client. But Julian Assange angrily tweeted, "Detained for 7 years without charge, while my children grew up and my name was slandered. I do not forgive or forget." Following the decision of the Swedish authorities to discontinue the investigation into Julian Assange, there was no longer a requirement to extradite him to Sweden. So what was the position then in relation to the warrant for his arrest for failing to surrender to the custody of the court? Well, on the 6th of February 2018, a judgment was issued by Emma Arbuthnot following an application on behalf of Julian Assange that she withdraw the arrest warrant. Now, I've put a link in the description to the judgment for further reading, but in essence the argument put forward by Julian Assange's lawyers was that following the investigation being dropped, the warrant had therefore lost its purpose, and that no Section 6 Bail Act proceedings had been initiated, and that the Section 7 warrant in this case was now obsolete and there are no underlying proceedings. This argument, however, was rejected by the judge, who stated that it is not uncommon for Bail Act offences to be pursued when substantive proceedings are no longer in existence. Section 7 is a method by which an absconder is brought to court for the court to decide whether to proceed under Section 6 of the Bail Act, whether in criminal or extradition proceedings. Julian Assange therefore remained in the Ecuadorian Embassy until the 11th of April 2019, when his diplomatic status was revoked and the police entered the embassy at the invitation of the Ecuadorian government and he was arrested. He was brought before Westminster Magistrates Court, and proceedings under Section 6 of the Bail Act were initiated against him. Now, Section 6 of the Bail Act 1976 states, if a person who has been released on bail in criminal proceedings, and this has been defined to include extradition proceedings, fails without reasonable cause to surrender to custody, he shall be guilty of an offence. Now, the maximum sentence for this offence was 12 months imprisonment. Julian Assange pleaded not guilty to an offence under the Bail Act, and he stood trial. His defence was one of reasonable cause, whereby if you can prove that the failure to surrender was justified, you are not guilty of an offence, as outlined in Section 6.3 of the Act. Now, this was rejected by Westminster Magistrates Court, who found him guilty. His case was then remitted to the Crown Court on the basis that the likely sentence would be beyond the powers of the Magistrates Court, who could only award a maximum of 3 months in accordance with Section 6.7 of the Act. Now, Julian Assange's case was sent to Southwark Crown Court, where he was sentenced to 50 weeks imprisonment, which is just below the maximum for this offence. The reasons outlined by the judge are in the sentencing remarks, which I've put in the description below. But the main reasons were he deliberately put himself out of reach by entering the Ecuadorian Embassy. His continued residence there cost £16 million to the taxpayer in relation to the police officers that had to be stationed outside, and that he did not surrender willingly to the court. The judge concluded that this was a very serious offence of failing to surrender, which, in her view, justified a sentence near the maximum. She also refused to reduce the sentence on the basis of Julian Assange being stuck in the embassy for 7 years. The medical evidence put forward by 2 experts as to the mental and physical effects of being stuck in the embassy also offered limited mitigation in the judge's view and amounted to a nominal reduction of 2 weeks from the maximum, as did the views of the Working Group on Arbitrary Detention. Now, Julian Assange was remanded into Belmarsh Prison, where he remains today. Julian Assange's continued detention is beyond the scope of this video, although I should say there are a number of high-profile figures from all corners of the world calling for him to be released. If there is enough interest in this video, then I'll look to do another video about why he is still in prison, despite the fact that his 50-week prison sentence has now expired. To summarise this video, once Julian Assange's extradition had been confirmed after the failures of his appeal, then he was required to surrender to Belgravia police station, which he failed to do so. Now, the merits of whether or not the extradition should have been granted is a separate argument. I'm purely focusing on the application of the law here. By going into the Ecuadorian Embassy, he was failing to surrender to the custody of the court in the eyes of the law, and therefore when he was finally arrested, he would be subsequently charged for it, irrespective of the fact that the rape allegations in Sweden had since expired. The sentence of 50 weeks imprisonment was indicative of the court's view of the seriousness of this, particularly when the mitigation put forward seemed to be pretty significant in relation to the mental and physical effects, and also the fact that he'd spent 7 years in the Ecuadorian Embassy. What I've sought to do in this video is explain how the law operated in relation to his failure to surrender to the custody of the court. Now, you may not agree with the law, but hopefully you can understand what I've explained in this video. That's it for this video. If you have any comments, then please drop them down below. I look forward to engaging and debating with you, even if you don't agree with the law or something that I've said. If you did enjoy this video, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.